Hello, and welcome to this week's episode of the Illinois Appellate Roundup, where we tackle recent Illinois appellate and Supreme Court decisions that represent important developments in appellate and post-conviction law. Whether you practice in this area yourself, or you or a loved one is facing an appeal or a post-conviction matter, I break these decisions down in plain English, what the court decided, and what it could mean for you. Today, we follow a criminal case across three of its stages: the evidence heard at trial, the sentence handed down, and the long road of post-conviction review. Our first case asks how much a forensic expert must explain before a jury is allowed to hear her conclusion. Our second asks what happens to a sentence when the court is told the wrong range of punishment. And our third carries us to the meeting point of youth, science, and the Constitution, where just this week, the law itself changed beneath our feet. For each case, I'll give you the holding, stated plainly, and the takeaway for your own practice. Let's begin where a trial begins, with the evidence. Our first case comes from the 4th District, and it turns on a single strand of DNA. A man named Taylor was convicted of murder. Part of the case against him rested on the testimony of a forensic analyst who told the jury that Taylor could not be excluded, that he was, in the language of the field, included as a possible contributor to a mixture of DNA found at the scene. On direct examination, though, the analyst did not walk the jury through the fine detail of her method, the precise steps, the statistics, the way she interpreted a sample that held more than one person's genetic material. Taylor argued on appeal that without that foundation, her opinion should never have reached the jury at all. Here is what the 4th District held. It affirmed, and it did so on a principle that every trial lawyer should keep close. Under the rules of evidence, an expert may state her opinion first, and the material she relied on to reach it goes to the weight of that opinion, not to whether the jury may hear it. In other words, the gaps a lawyer sees in an expert's method are not a reason to keep the opinion out. They are an invitation to cross-examine. The burden sits with the opposing lawyer to draw out those weaknesses in front of the jury and to argue that they make the opinion worth less. The court went further and set aside an older decision that had pointed the other way, calling it an outlier that had asked too much of the party offering the expert. It also held that the evidence as a whole was sufficient, and that the sentence, 57 years, was not an abuse of the trial court's discretion. The conviction stood, and here is the takeaway. If you are facing an expert whose foundation looks thin, a forensic analyst, a crime lab, a DNA mixture, do not expect the trial court to keep that opinion out simply because the method was not spelled out on direct. In Illinois, that is not a door to exclusion, it is a door to cross-examination. Prepare to do the work in front of the jury. Make the expert show her math, expose the assumptions, and give the jury a reason to doubt. The foundation you wish had been laid is yours to demand out loud, on the record. Our second case moves from the trial to the sentence, and to a mistake about the numbers that can undo an entire hearing. It comes from the 3rd District, out of Kankakee County. A man named Boyd had pleaded guilty and been placed on probation. When he pleaded, the court told him what he was facing if things went wrong, a sentence somewhere between 3 and 7 years. Later, his probation was revoked, and he came back before the court to be sentenced. This time, the state told the judge a different story, that Boyd now faced an extended term, 3 to 14 years. The judge, working from that understanding, declined to give the minimum, called the state's request for a 10-year term understandable, and imposed a sentence of 7 years. Here is what the 3rd District held. When a defendant's probation is revoked, the court may sentence him only up to the maximum he was originally told he faced when he entered his plea. Boyd had been admonished to a ceiling of 7 years, and so 7 years was the true top of his range, not 14. The state's representation that he faced an extended term was simply wrong. Now, the sentence he received, 7 years, did happen to fall inside the correct range, but the court refused to treat that as harmless. Listening to the judge's own words, declining the minimum, describing a 10-year request as understandable, the appellate court could not be confident that the judge had not been influenced by the inflated ceiling hanging over the hearing. That, the court held, was plain error of the kind that affects the fairness of the proceeding itself. It vacated the sentence and sent the case back for a new sentencing hearing, this time on the correct range. And here's the takeaway. After a probation revocation, go back to the beginning, to the admonishment the defendant received when he first pleaded. That first stated maximum is the cap, even if an extended term might otherwise have been available, and even if no one at the resentencing seems to remember it. If the range in the room is wrong, the sentence can fall apart, because a court that sentences in the shadow of a punishment the defendant never truly faced has not given him the hearing the law promises. Check the original numbers and hold the state to them. Our third case takes us to the far end of the system, to post-conviction review, to the science of the young brain, and to a law that changed this very week. It comes from the First District. A man named Sanchez is serving a mandatory sentence of natural life. He was 20 years old at the time of the offense, what the law has begun to call an emerging adult, no longer a juvenile, but not yet fully formed. Years into his sentence, he sought to file what is called a successive post-conviction petition, arguing that a mandatory life sentence imposed on someone his age violates the proportionate penalties clause of the Illinois Constitution, the promise that punishment be measured against both the offense and the person. He faced a wall. He had raised the question of his youth once before, on his direct appeal, and so the doctrines that discourage repeat litigation and the demanding cause and prejudice test for successive petitions stood in his way. But the First District held that fundamental fairness could relax that bar. The reason was new evidence, a developing body of science on the adolescent and emerging adult brain, brought forward with his lawyer's supplement and his own sworn affidavit. Taken as true, the court held that showing was enough to establish cause and prejudice, and enough to make a substantial showing that his life sentence is unconstitutional as applied to him. One detail mattered a great deal. At the original sentencing, the judge had said, in effect, that he was not convinced life was the right punishment, but that the law gave him no choice. The appellate court reversed the dismissal of the petition and sent the case back for a full evidentiary hearing, where that question can finally be heard. A dissenting justice would have let the dismissal stand. Now here is what makes this week remarkable. The very barrier Sanchez had to climb, the requirement that a young petitioner show cause for not raising his youth sooner, the legislature has just removed. This week the governor signed a new law, Senate Bill 248, into effect. For a person who committed his offense before the age of 21 and who files a successive petition claiming his sentence violates the proportionate penalties clause, the law now eliminates the cause requirement altogether. The background is a decision our Supreme Court handed down in 2022, which had held that these petitioners could not show cause, precisely because they could have raised their youth in an earlier petition. That reasoning had closed the door on many. The new law reopens it. A petitioner must still show prejudice, still show that his youth mattered to his sentence, but he no longer has to explain why he did not raise it before, and the law took effect immediately. And here is the takeaway. If you represent someone who was under 21 at the time of his offense, serving a sentence he believes is disproportionate, the path that Sanchez had to fight so hard to open is now, by statute, open at the threshold. You still must prove prejudice and prove it well. But the cause requirement, the barrier that had turned so many petitions away at the door, is gone. Between a court willing to let fundamental fairness soften an old rule and a legislature willing to rewrite that rule outright, the law this week moved decisively toward hearing these claims on their merits. So here is the thread that ties this week together. At trial in the Fourth District, the law tells us that an expert's weaknesses are a matter for cross-examination, not exclusion. At sentencing in the Third District, it tells us that a court must sentence within the range the defendant was truly promised. And in post-conviction in the First District and now in a new statute, it tells us that youth is not a question the law is finished asking. From the evidence to the sentence to the long road afterward, the system keeps returning to a single question. Has this person been given the hearing the law truly owes him? Thank you for watching this week's episode of the Illinois Appellate Roundup. If you are in need of appellate or post-conviction representation, please do not hesitate to call me directly at 312-517-3877. I'll see you next week.